Good afternoon, everyone. It's great to see so many familiar faces and some new faces. To those who do not know me, I'm Miriam Heipitz. I'm a PhD candidate at the Amsterdam Center for International Law and the Amsterdam Center for European Law and Governance. And it's a pleasure for me today to welcome you to the ACELG's first external speaker event of the year. And I'm delighted that so many of you could make it in person and some online. Welcome to the people online. Let me introduce our speaker today, the wonderful Hanna Eklund. She made it here from Copenhagen and will give us a sneak preview to the forthcoming volume with Cambridge University Press titled Colonialism and the EU Legal Order. Hanna is an assistant professor of constitutional law at the University of Copenhagen. She holds a PhD in European law from the European University Institute in Florence and was previously a postdoc at Sciences Po Paris. Her research focuses on colonial histories in EU law, and currently she's leading the project Colonialism and EU Law, Writing Legal Histories for the Future. In today's talk, she will challenge in her words, or recalibrate the dominant narrative of the EU project as one of only peace and unity, showing colonial legacies in the EU, and will critically engage with the ways in which the EU law has been built on and has reproduced colonial structures. And that hopefully will open up our thinking about the role of law in shaping Europe's past, present, and future.
Thank you very much. Thank you for this invitation to come here, and thank you to Miriam for organizing this seminar, and thank you for your interest in coming here, your interest in my research. So I will talk about colonialism and EU law, and I will first talk about why we should do this research into how the history of European colonialism have shaped the development of EU law. Then I will say something about how to do it. How do we theorize, how do we analyze connections between Europe's colonial history and development of EU law? And then last, I will say something about how to use it. How should we use those insights into the ways in which colonialism has played a role in EU law and its construction, and especially how should we use it to suggest how to change the law as it is today. So I'll start with the why. And in order to answer the why, I feel like we need a definition or some version of a definition of colonialism so that we know what we're talking about. And many people who have written about colonialism, and I won't cite all of them, they talk about the dual claim, the double claim or the dual claim or the dual meanings of colonialism. And they say that it's both a historical reference to a period of European expansion that covered hundreds of years. First to South America, and later, but not excluded, to Africa and Asia. And the former rule that this territorial expansion brought with it was one of unjust domination of one people, of one country over another. It was one of economic exploitation of those colonized. And it was one where legal systems were used to organize the economic exploitation, but also used to create racial hierarchies between groups of people. So in becoming a concept, let's say, the characteristics of this historical period are taken up, becomes transportable, and are used to describe other situations, other places, other events outside of those hundreds of years of European expansiveness. So it's a historical reference to a form of rule with characteristics that are portable. But I would also like to say that I find that there is almost something dizzying in the term colonialism that I think we should acknowledge. It covers hundreds of years. It refers to millions, the experience of millions of people, of a myriad of different laws, types of laws, of traumatic events, and of flows of money. And we are distilling some of the core features drawn from this very long history, and we turn it inwards and towards the European Union. And we try to say something, I try to say something about how it has been affected. So Amis Assad was one of, he wrote discourse on colonialism, among other works, and he, as is not atypical, or that is fairly typical of this type of anti-colonial, post-colonial political leaders, that he was both a poet and a politician. And he wrote about the boomerang effect of colonialism. And what he means by that is that, of course, we have, and we should look at how colonialism has affected those colonized, the harm that it has done to those colonized. But we should also, as Amir points out, we should also look at how colonialism have shaped, or have affected, have impaired, harmed the colonizer. That's the boomerang, how it comes back to the colonizer. In our case, it is a supranational organization that we're looking at, founded by member states who used to be, and to some extent still are, colonial powers. And here we come to the why we look at colonialism and EU law. And I would suggest that it is to expand the account of who has been subjected to EU law and how people have been subjected to EU law. And it is to broaden the account of which legal systems, type of lawmaking, and more generally places have shaped the development of EU law. And in so doing, in forcing this expansion, we can see how EU law interconnects to the legal and political development of places outside of the European continent. And we can see what colonialism did to the development of European societies, to European laws after the Second World War and the period of formal decolonization. So, how? How do we research the connection between colonialism and law? How do we, on the one hand, account for continuity from colonial rule by member states through the creation of a supranational organization and onwards? And in addition to thinking about continuity, interconnected to thinking about continuity, but differently from thinking about continuity, how do we use the knowledge of how colonial laws worked to assess the laws of today? So what do we do when we see a repetition today of forms of lawmaking that was present in colonial times? So I will say something about continuity, and I will say something about repetition. Colonial continuity is a term that is used quite widely in sort of post-colonial theory. It is used very productively in TWAIL, so Third World Approaches to International Law scholarship, and that for decades. And it's also used in other disciplines, of course, outside of law. And it is meant to describe a practice that continues from colonial rule into decolonial times after formal decolonization. And to make most use of this term, I propose and I suggest that we construct it very tightly, that we construct it as the unbroken operation of something over time. So it's not, continuity is not about identifying a mere resemblance or to something that feels kind of colonial. And I insist on this precision, on being precise, because an overuse of the term colonial continuity risks watering down our ways of thinking about how practices have continued, to the extent that the actual unbroken lines will be harder to identify. So, what are examples of where EU law has sustained the unbroken operation of colonial law, of legal practice, of legal categorizations over time? Now, I would suggest obvious and unavoidable example is the overall structure of so-called, in EU law lingo, OCT law. And OCT stands for the Overseas Countries and Territories. And it was a term inserted into the first treaty of the EU, the Treaty of Rome in 1957. It was created to associate member states' colonies to what was then called the European Economic Community. And association was constructed to encompass trade, so that the trade of the associated countries and territories was decided in Brussels, and investment through the contemporaneously created European Development Fund. What was, however, excluded from association was rights or benefits for people living in these associated countries and territories. So, and it's also important to point out that there was no representation during the negotiation of the Treaty of Rome. There was no representation of any kind from the territories that were to be associated. So no political representation of anyone from there. So the number of colonies in Europe have shrunk. And so, of course, has the number of associated countries. And the themes that, when to go from, say, primary law into decision-making in the area of OCT law, the themes are somewhat different. So in 57, you were talking about political, or sorry, you were definitely not talking about political, you were talking about economic and social development, whereas now you would be talking about sustainable development. So there's a little difference in the language. But if we look at primary law, the legal language has remained unchanged since 1957. And I do want to insist on the example of the use of the word inhabitants to describe the peoples who lived in the overseas countries and territories. And already at the point of drafting, the choice to use inhabitants was deliberate because France, and also supported by Belgium, did not want to use the term peoples, because peoples was a term with legal stakes. It implied self-determination. And so they did not want to use that. And instead, they used the term inhabitants. And this has not been changed. And those of us who know perhaps more about it, you know that the treaties have changed several times. So there's been opportunity, let's say, to revise this language, but it has remained intact. So this is an example of continuity, of a legal category that stems from a colonial type of lawmaking, ways of reasoning, way of thinking that has remained. So I would say that OCT law, and I'm just taking one example from this body of law, is an unavoidable example. The book that I've edited that Miriam mentioned that is coming out later in the year, it's called Colonialism and the EU Legal Order. And it is an interdisciplinary book. It has 16 chapters, and there are different examples, other examples of, of continuity. I will just mention two. For instance, how early EU social security regulations upheld the distinction between workers from the European metropole and the colonies. And it upheld that distinction. The author of this chapter shows his name is Karim Fatik, all the way into the 1980s in different ways. Another example is that is a continuity that we can trace from colonial times up until 1980s. And then another example is the EU's involvement in the governance of the CFA franc, which is a currency that is used in West and Central Africa. Now, the CFA franc is a colonial currency, and that is still used. And of course, these countries are independent countries, the countries who use the CFA franc. It is more than 160 million people every day who use this currency. However, the way in which the governance of this currency is structured, with the involvement of the French Treasury and the involvement of the Council of the EU, it is let's say, controversial to say that these countries do not have monetary sovereignty. In order to reform this currency, you would need, if you were a country, you wanted to reform the use of this currency, and several countries want to do that, especially in West Africa, you need, according to the EU, the approval of the EU. So this is another example of where a member state's colonial practice, way of, in this case, governing and regulating a currency in its former colonies, been taken over, let's say, or continued by the European Union, by the Council. So these are two examples, but I just want to go a little bit into the detail and just say something about how do we do this? How do we sort of establish this continuity, if that's what we want to do in our analysis? And there, of course, law has certain benefits. It is written down. It tends to continue. It is interpreted. It is drafted. So what we can do when we're looking to establish this form of continuity is that we add together regulations, also those who are no longer in force, directives, preparatory works, archival material, and piece together the unbroken operation of colonial legal techniques, ways of reasoning, of categories. So what we do here is we start in colonial times and we trace something forwards, but we can also start in present times and trace something backwards. And this is what I want to turn to now, say something about now, when we start today and trace something backwards. So when we look around at the type of lawmaking, the type of legislative proposals that we have, what do we see? Could we see a repetition of a form of lawmaking that was present or that was used during colonial times? So what I want to say something about is the value, analytically and normatively, of acknowledging repetition. So the repetition of lawmaking, ways of constructing legal categories that are similar to the colonial era and that reappear today. And I will take 2 examples. First, laws that seek to treat citizens differently based on their ethnicity or race. Now, this is a core, I would say, core element of colonial lawmaking, to find ways, legal ways of distinguishing, of differentiating between citizens or people subjected to the same state based on their ethnicity or race. This is an essential element of that type of lawmaking. And this is, I would argue, a form of lawmaking that is returning. Now, in Denmark, where I work, or in Sweden, where I live, there are several examples of laws that seek to do this, or proposals, legislative proposals that wants to do that, or executive orders or administrative decisions that wants to do something like this. And I would assume that perhaps you come from other European countries and you could perhaps give me examples from your countries. And so what we see is example of these types of lawmaking, of decision-making, of administrative practices that are coming all over Europe. And this constitutes a test, I would argue, for the Court of Justice of the European Union. How will it handle these types of laws, decisions that are popping up around in member states? How will it interpret, especially Article 22 of the Charter of Fundamental Rights of the European Union, the Article of Non-Discrimination? How will it interpret the Race Directive? Will it strike down national laws that seek to differentiate between citizens based on ethnicity and race, or will it uphold them? And if it chooses to uphold them, what it's doing is that it is upholding, it is sanctioning, it is accommodating a form of lawmaking that was typical of the colonial era. It is accommodating a repetition of colonial lawmaking. Now, in the case Jyske Finans, which is a Danish case about 2 Danish citizens who wants to take a car loan, and they are forced to provide different forms of documentation depending on their ethnicity. In that case, the Court of Justice said, okay, that's okay. Which I would argue it missed the test in that case. Now, any day now, there is a new case that is before the Court of Justice. Again, Denmark. It concerns the so-called ghetto laws of Denmark, where people of non-Western origin, citizens, I should say, of non-Western origin, have been asked or been forced to move from their homes because they're demolishing or they're reconstructing the area where they live. And the question is, what will the Court of Justice do? Will it uphold this law or will it strike it down? So this is an example, I would say, of a question of whether or not we will have a form of repetition in European law at this moment in time. One example. The other example I will take from the area, and this is a broad umbrella term, but the area of external action of the European Union. So when the EU engages with the rest of the world, and in particular when it engages with its former colonies. So there are several examples in this book that I mentioned before, taken from external action and trade more broadly. And these examples, let's say, have some common features. So what they're suggesting is that the EU, vis-a-vis its former colonies, have a type or a style of policymaking or actions whereby fairly self-serving policies, paternalistic policies, are dressed up in a language, a little bit depending on the decade, but in the language of cooperation, of partnership and development, and so on. There are, for instance, 2 chapters which discuss the example of Algeria. Both Daniela Caruso and another scholar named Amel Ben-Yedal, they talk about the EU's relationship with Algeria, and they describe, if you read those 2 chapters together, how the EU time and time again is returning with, let's call it, awkwardly yet elaboratedly formulated policies, like, say, the EU's neighborhood policies or the Union for the Mediterranean, or they might have a kind of a name like this, which barely conceals a set of self-interested policy goals. It could be in trade, it could be in structuring markets of produce and so on. Another example of the same type of mode of interaction I would draw from international treaty making, from the negotiation, which was quite recent, of the BB&J agreement, which is a kind of a part of the law of the sea convention, and BB&J stands for biodiversity beyond national jurisdiction. And I'm not an expert in this, but what it means is who gets to dig and mine the deep sea, essentially. So when we begin to mine the deep sea, how do we regulate that practice, and who will be able to profit from whatever they find in the deep seas? So this agreement was concluded, this treaty was concluded just about 2 years ago. And so in this negotiation, the EU opposed, let's say, any real articles, any real rights of distribution that would have guaranteed, let's put it that way, any real mechanism that would have guaranteed the fair distribution of whatever profits would come out of this mining. And while trying to water down such provisions, it at the same time had a language and an approach of, well, you can use my funds, and we have funds that are called the blue funds and the green funds, and we will spread them around, and we will, development, and we will assist the partners. So there was a fairly a way of negotiating that was also criticized at the time, of watering down the actual hard law, while at the same time presenting this position in a language, a euphemistic language, that in some way concealed, let's say, a different type of position. And this is also similar to the origin of association. Just to perhaps repeat myself again, no actual deliberation, no actual negotiation, but a language of development. And so what I'm getting at here is basically a repetition, not a constant, but a repetition of a form of position that rejects actual reciprocity covered in a euphemistic language. So those are 2 examples of repetition. And I just want to say something about the point of identifying repetition. And I would say there are 2 or 3. One is that we can better explain the effects of contemporary law, of practices of policy making, when we use colonialism and its characteristics as a foil. So there is a clarity to the claim of repetition. When we show that policy that, for instance, treat people differently based on race and ethnicity is not an exceptional event, reaction to an exceptional situation of some sort, but it is part of a lineage of practice of how we treat people in Europe. That is a meaningful observation. And I think that Césaire's boomerang effect here is again a helpful picture, because we acknowledge the interconnected effect of colonialism when we trace its logic, its form of lawmaking, its repetition to European laws and society. Identifying continuity and repetition should be done while at the same time accounting for discontinuity. So I am not in any way suggesting that this is a grand theory that explains everything. It is not at all. But rather, I would say it's a way of being precise with what's going on, or what has been going on. So it is, for me, a way of providing a clearer analysis of certain types of law and certain types of policy practices. So now, at last, I will say something about how the analysis of continuity and repetition can be used to produce change. And here I am interested in reform. I'm interested in changes to the law. I'm interested in reassessing legal language, to propose, of course, now this is the scholarly activity, to propose, to illustrate why. And I have already now mentioned a few examples. I have already mentioned looking at the concept of inhabitants in Article 198 of the Treaty of the Functioning of the European Union. I would also suggest that you should look at Article, now this is for the EU lawyers now that I signed the treaty, for Article 202 of the Treaty of the Functioning of the European Union, which is from the same section. And that says that there should be a difference in treatment between workers from the member states and workers from the associated countries and territories. So just notice the legal language there. It is not a question of who is a citizen where and who's not a citizen where. It is a question of from, which is an indicator of ethnicity. It's not an indicator of a civic connection. So that is another example of a type of legal language that I think we should illustrate, and we should suggest what to do with it, take it away, change it. Another example is, as I've already mentioned, the EU's involvement in the governance of the CFA franc, and this is just by way of exemplification. There, as late as 2021, the EU again insisted on its own decision-making power when it comes to approving reform of this currency in West Africa. And I do not understand where the justification for that comes from. That is something we can illustrate, and that is something that we should point out. And of course, explain what would be a legally coherent application of Article 21 on non-discrimination of the Charter of Fundamental Rights of the European Union and of the Race Directive, and follow the case law that is clearly to come. So I think that when we see continuity, when we can establish continuity, when we see repetition, we should provide an alternative. We should at least show how the law should not be written and how it could be written. So looking at a political trend that we have right now, of a rhetoric of dismissiveness, of growing social inequality, of laws that seeks to privilege national ethnicity over citizenship. In this political context, I would argue that the analysis of how colonialism has shaped contemporary law cannot be declaratory. It cannot be abstract, and it cannot be tendentious, but it has to be accompanied by clear, concrete proposals. And it needs to be part of, and here I am just again returning to the examples I have already given you, needs to be part of, I believe, illuminating the need for EU to exercise humility on the global stage and egalitarian interaction with other countries and organizations that it has itself designated as partners. Asking the EU to leave paternalistic practices behind. And this is not just idealism. I believe that this is also strategic. And we should use this to sharpen the identification of laws in Europe that sustains what Pater Chatterjee has called rules of difference between people based on ethnicity and race. We can, of course, talk about colonialism as colonialism, and I think that is an important exercise in and of itself. But we should also acknowledge that colonialism is just one way of finding inequality built into law. And once we have acknowledged this types of inequality, I believe we should show how to change it. Thank you.